So welcome everyone to this Privacy Kitchen coffee break with Tom McNamara, the founder and CEO of Apex Privacy and the Data Privacy Podcast, which I recommend to everybody to go and have a look straight after watching this. So welcome, Tom, to Privacy Kitchen.
Cheers, Robert. Cheers for having us on.
You're very welcome. I see you're in your kitchen as well, blackboard behind you.
Yeah, I thought just to keep up like the authenticity of Privacy Kitchen, I'd have to come down here.
Fantastic. Thank you very much. Appreciate it. And just straight off the bat, I'll just say this is not legal advice, this session. It's going to be a really interesting conversation from the conversations we've had and also from comments on LinkedIn posts over recent history. So this is an incendiary topic. There's a lot of strong beliefs around this, but it's definitely not legal advice, this. So but let's crack on to the first question. So this is all around DPOs and conflicts. And so we've put on the thumbnail a few different bits and pieces. So we had the first one of can your in-house DPO, if you have an in-house one rather than an external one, ever not be conflicted? And so what we're doing in looking at this question is we're not asking, do you need a DPO? We're leaving that out separately. We're not asking, does a DPO come out of the silo and become a strategic business partner? That's coming in the next session. Here we're just looking at that conflict part, not just, but we're looking at the conflict part. So that's the first question. Can an in-house employee DPO ever truly be not conflicted?
Well, I suppose it's probably good to start to look at the provision and see why you don't want your DPO to be conflicted. And probably the writers of this regulation wanted an independent and objective view of data processing within the business. So like, I guess there's the obvious conflict where if you're in charge of a processing activity, for example, let's say marketing, because it's probably the easiest one to point out. If you're the chief marketing officer and you're being judged on the performance of your marketing initiatives, can you objectively look at that from a data protection point of view and say, here, maybe we're not meeting the requirements here, maybe there's data subjects' rights that are impacted? And that's very clearly a conflict. And I think that's the black and white one that most people should be able to see, and that extends to HR, extends even to finance. If your role is being judged on performance and you're in charge of a data processing activity, then you can't objectively stand back and look at compliance and look at how you're protecting the individuals. I think that's quite black and white. If you go on, and again, the GDPR is wrote for every type of organization. So it's your SMEs, it's your mid-market, it's your enterprise clients. So if we were to look specifically at the DPO in an enterprise organization or even a mid-market, can they, if their full-time role is the data protection officer, but they're on payroll, they're subject to the same staff policies, the same company policies, like they don't sit in that ivory tower. They're actually part of the business. They have lunch with everybody else. They have friends within the role, within the business. So I think that's where the conflict piece starts getting really like grey. And I think GDPR is kind of the law of grey areas because we're still working through so many of them.
The G might as well be for grey. Yeah, absolutely.
Yeah, so I think like when you get down to that level of granularity, you're like, okay, if the DPO is unconflicted and there's no obstruction on how they perform their duties, can they send out a mass communication to all staff calling out the business or calling out processes without going through formal communication policies? So like, I don't know if you can sit within that role within a business, as I said, on payroll, subject to the same company and employee policies without having some level of conflict.
So it's an interesting one because I think what you've put your finger on there is there's different ways of looking at conflict. And we were just saying in the previous, we've both got legal backgrounds. And so maybe the conflict bit sort of stands out to us in a particular way because lawyers are very aware of, and there's a long history of, well, I shouldn't say long history of conflict, a long history of dealing with conflict in the legal profession. But so I think the way that the GDPR, the way I see it drafted is the roles, the tasks can't lead to a conflict. So what's really interesting about what you've said there as well is is it's not just the task. So obviously if they're a CMO, and the UK ICO gives that example of a senior marketing manager deciding who to target on a campaign and being on the hook for the benefits of that campaign to the business. But you put your finger really nicely on the fact that these people are in the business. They're having lunch with people, at the water cooler with people. There's a tension now on how you actually can advise and how you deal with conflict in terms of if you disagree with the business. And that actually the EDPS in their 2018 update of their report on the European Union institution DPOs actually called out this bit and said it's not just the task conflict. There's a cultural conflict in a way, or it's just inter-company societal conflict that's an interesting one. But you mentioned, we mentioned on the thumbnail as well about lawyers and MLROs, and what about that conflict, dealing with that conflict as an MLRO? Because really, in a way, that level of conflict is in every role. You know, you're a marketer, you want to do something, and legal says no, you can't because it's against this law or that law. Or the CEO says I want to go into this jurisdiction, and the CFO is saying no, I don't want to, or for whatever reason. And so, or a procurement person is blocking something someone wants to use in a particular department. So those sort of inter-role conflicts in that sort of business conflict happen quite a lot, don't they? So what about the MLRO lessons from that a DPO can take?
Well, I suppose just taking a step back there, when we talk about conflict, and just say from the legal point of view, you're usually looking at an outside representative, like being conflicted over having two clients in the same market or operating in the same silos. But when you look at the possible internal conflict, that's when it really becomes, I think, nearly unmanageable. You know, so what's different, and what I think definitely when they were writing this legislation, they were looking at the MLRO, because the core function of the MLRO is to oversee compliance with money laundering regulations, and the DPO is supposed to oversee compliance with data protection regulations. But there's a few caveats in there. They don't call out a conflict within the MLRO piece because the personal liability on the MLRO is so high. So I think it makes people stand back and say, here, I don't want to be MLRO because I'm open to personal fines. I'm open to prison sentences. Do you know what I mean? So I don't think so many people would be putting their hands up to be DPO if you were on the hook for the failings of your company. But I suppose there's different objectives there, in that the MLRO is required to report breaches, whereas the DPO is under a duty of confidentiality. So I guess they probably wanted to go so far, but they stopped before they went to the extent of putting the companies on the hook and putting people within the company on the hook to report out. You know, now at the moment, they're waiting for internal investigations or breaches or complaints. And I imagine, again, I'm putting thoughts into their minds, but the way the DPO is described in the regulation, it's like, okay, if they have to do all this reporting and they have to have all these communications and calling out bad practices, when we do get this company in front of the court and we've made our discovery proceedings, we'll be able to pull up all these files and call out Mr. Zuckerberg and call out Mr. Dorsey and the likes of that. So I think there's objectives unsaid within the role of the DPO, and I guess we're out here trying to interpret it best as we can. But again, that's my own thought, so maybe I'm completely wrong.
No, I think it's a really interesting one, because there's the GDPR is the GDPR took so long to come through and was really fought over. But I think what happens is you get things like a lot of people have vested interests and that they wanted a provision to say something and they didn't get it. So for example, representatives, the liability of representatives, you know, the EDPB, they clearly wanted the representatives to be on the hook for all the fines, the same liability as their clients, which is ridiculous because it would totally close down. No one would want to be a representative, like you were saying about MLRO. And in their first territorial scope guidelines they put out for consultation, it was a really nicely, loyally done sort of breakdown of territoriality and scope. And then just at the very end, they bunged in a paragraph going, oh, and by the way, the representative's on the hook for the full fine of their clients. And luckily, they changed that for the one that went through to publication and clarified that the representative's only on the hook for their own tasks in under GDPR, not for their clients. And I think there's a lot there of legitimate interests, when you can rely on it, when you can't. There's a lot of different interpretations, different viewpoints, and so this is one of those areas where I think it is quite muddy. And I think your comment there about where they might have been wanting to go and actually didn't manage to get far enough is a really, really interesting one. And it'd be interesting to see that, as we were talking about earlier, some of these questions challenged in the court, and to see how far they actually get through with some of these positions.
Yeah, most definitely. So we're still like, it's such a new law. I keep telling people that we're still signing contracts based on decisions that were made back in the 1800s.
Yeah.
Do you know what I mean?
Yeah.
So like, there's a lot of refinement, there's a lot of decisions, and I guess moving away from grey to more black and white.
Yeah.
So we're really in the early stages of this, and each person's going to have an interpretation and an opinion on where we are, where we're going, and why it was put in there to begin with.
Yeah, and I think that conflict bit is so for me, like there's certain things in finance. You have to have a particular officer if you do certain functions, and that person can have personal liability. But I struggle to think of any general law that says any business, it must have a lawyer, an in-house lawyer in these situations, or it must have an in-house accountant in these situations, or any other thing. And so this to me stands out like a sore thumb in law, going, you have to have this sufficiently expert person that's independent for this one particular area. I think just taking the conflict away would make it really easy. I think that's where a lot of the tension from commentators come from, about companies wanting a DPO and then wanting to do more. And I was wondering, you're in a great place on this because you do DPO as a service. I was wondering what your thoughts are on that.
Everybody wants to put themselves out there as not just checking the boxes, but to read
Yeah.
the conflict piece, you're being brought in as a DPO to check boxes, because physically you're not supposed to be doing anything else. I don't think, again, I'd love to see it go through the courts and challenge the fact that somebody who has run a project, set up processes, advised on them, like really been involved in the business, they can't act as DPO because they're conflicted in what they've delivered. But I think that they have to. Like, again, the clients that I work with need more than just someone there to either work on somebody else's processes or work on an existing process and refine them and advise. But how far does advisory come before you're making the process? Do you know what I mean? Like, there's really so much overlap there that a competent DPO who's confident in delivering compliance programs should be able to set up that program and oversee it without being conflicted. And like, I think that there'd be very strong grounds, as long as you can show your work, then you can correct your own homework. Do you know what I mean? Like, if we're going down that analogy.
Interesting. So I wasn't expecting you to go there. That's very interesting. So here's a different question. How many times when you're asked about being a DPO, or people have said they've got a DPO, that you've seen it? How many times have you seen it where that's valid and they needed one? And how many have you seen it where they just didn't need one and they've called someone a DPO because they think they have to have one? Or
yeah, I think early days it was happening a lot more. You know, it was over 50% of the people you talk to would have appointed someone before they sought external help. And usually that person is in the C-suite, the CEO, or somebody who's working in a purely admin job who has no kind of authority within the company. And right now, I think it's evolved a little bit more. People are a bit wiser, they understand. But again, it's still out there, and it's still so unclear, like, how far can you go in advising before you're making? And I think a lot of the practitioners, like the DPO consultants that I work with, they're like, no, we're here to drive more than just checking the boxes. We want to help them with their whole process, and that involves getting into the weeds. You know, conducting a DPIA, you have to be in there with them. Do you know what I mean? Like you have
So
to
that's an
advise.
interesting one. So they do say, the regulators do say it's not the DPO's role to do the DPI. This is an interesting one on your point about
Yeah,
where's the line, because they say the controller has to do it, or the process, not the DPO. But the DPO can advise when one's needed, advise whether it's being done correctly, and advise whether the result's right. Well, that's pretty involved.
to know, like advise if it's being done correctly. You're probably the person training them on data protection risks. So
Right.
if you're teaching them like exactly what to do, then are you not doing it in some way? Like you're checking the homework, fair
But this
enough.
is the whole
You've given,
ridiculousness of the conflict, because
yeah.
because arguably if you're doing the training, you can't then judge whether that training was sufficient.
Hmm. And like
So this whole
specifically,
conflict bit,
they call out that you're there to train. Do you know what I mean?
yeah,
Like, how does somebody approach a DPIA within a business without having been trained on how to conduct it? And if you're
yeah,
training it, you're leaving them to do it themselves, but you're stepping in to advise on how to complete it, and you're over like it really like I don't think it's workable. And I think a lot of people who have looked at the law from a pragmatic point of view have said, okay, we can run this risk because if we're called out on it, let them show us a solution. You know,
yeah,
let the let them really like come up with it. And I think going back to a point that you made before, like on how okay, anti-money laundering legislation looks like this, and you can't think of another law that's so kind of demanding. Like the GDPR didn't come out and say we're a technology law, we're a general law for processing data, even though some of the clauses and some of the articles are purely technology focused. Do you know what I mean?
yeah, yeah,
So
yeah,
if this was a regulation for ad tech or this was a regulation for social media, it could be get a lot more granular and specific, whereas it's trying to be so broad to capture everything. But the reality is that every different industry operates differently, and it's harder to have a voice then. So you'll know from financial services, all the banks, all the financial institutions get together to have policy groups that they can go back to the Bank
yeah,
of England or the central bank here in
yeah.
Ireland and kind of contest things. But because the GDPR spans all industries and all sectors, then it's harder to get a uniform view to challenge something like conflict that I don't see many people saying that it's going to work in any sort of way.
I think you're quite right about the law's it's not a workable solution. So I totally agree. I think the DPO is just such a non-workable solution, and I think the conflict is the issue. I think I think one thing is to say, do people actually need a DPO? Because I think a tiny minority of private companies need a DPO. The Law Society of England and Wales said the majority of law firms will just not need a DPO. And if you think of how much personal data and the type of personal data a law firm processes, the Law Society said you're unlikely to need a DPO. So I think the need for a DPO and a kickoff, I think the nomenclature could be different. A lot of people who are saying we're your DPO, they don't need to be the DPO, and they're bringing this issue on their head without any reason. So I think not having a DPO in the first place, if you don't need one, is one thing. But this brings us on to, can an external DPO be conflicted, which we've just sort of really talked about. Was there anything extra to add about the external DPO setup?
Yeah, I think you're spot on with really companies should decide or go through and get external advice. Do we need a DPO? Because you're just opening up these requirements and
Yeah,
these possible problems if you're appointing someone without actually needing to do it. And then
yeah,
you get down the ridiculous piece of, okay, if you give a different title but the same function, you're not on the hook.
yeah,
So
yeah.
again, like you call them a data protection champion or a data protection manager and they're not a data protection officer, does that mean that you haven't voluntarily appointed someone as per the GDPR? Does it have to
No,
be an
you're off the
official
hook.
registration
Absolutely, you're off the hook.
and the likes of that? But for the external piece, I think it really does come down to the external DPO advising on how to comply, running that compliance project, and then overseeing it at the same time. Now, you're only in trouble there if you have got a DPO who doesn't know what they're doing or hasn't done it to the best standards or best practices of what we have in the area. because you'll only be caught by that and have to answer those questions when something goes wrong. In terms of like, and then we just all come back to the same issues of how far is advising and the likes of that, and you're getting into the real technical aspects of pulling apart specific, like this is what lawyers do. They get specific words and specific articles and like write big opinion papers on what does advising mean or what does opinion mean and the likes of that. So I think from an external point of view, it's up to the companies to make sure that who they're working with knows their stuff, because I think somebody's going to be the case study, like is in front of the courts, like, and nobody wants to be that case study. But it will happen.
There's already been a couple. I mean, in Belgium, before the DPA, they fined a company 50,000 euros because their head of risk was.
But they weren't external. I think the external piece will be.
It was internal. That's true. There's no external one I'm aware of yet. No, that's right. But you make a very good point in terms of, there's such a low level of compliance with GDPR in my book. From talking to the market at the moment, people are still struggling with data inventories and how do we really do it, and retention's always a disaster. So I think that the conversation from the Europe point of view really needs to be focused on, let's help general compliance with the GDPR. Let's get more people compliant with the GDPR. Let's not focus on something like this, which is, in practice, as you say, what people want expertise. And someone might be calling themselves a DPO and they didn't need to be, or they might also be the DPO. But isn't it more important to get companies compliant first? And then we can go into this. So if you have an external DPO, as an organization, you can go, we don't have any conflict from any internal appointment because we've appointed an external one. That external company, being specialist at it and knowing more about it, can put in place the Chinese walls, they can put in place different legal entities, however they do it, that gives you a good answer on the conflict bit. And how many people are going to dig into this issue from, down to reach an external DPO and going into how they've put those Chinese walls in place?
And I think it comes down to, like, if they've done their job properly, there might, like, you can get into the weeds of conflict, but it'll be a non-issue. It'll be if they've done a shoddy job, and then the breach is the problem, or the non-compliance is the problem. And it'd be funny, or not funny, but it'd be interesting to see if a court decision did get down as far as this DPO put in place the program that they sought to oversee, and this was what caused the breach. I don't know if the joining those type of dots causation and the likes of that, to use the legal term, but it'd be interesting to see if that would come to the surface. So again, nobody wants to be the test case, but it probably will happen at some stage.
So I think just before we talk about Brexit very briefly, I think we're coming up to time. This has been a great conversation, as I knew it would, and looking forward to all the comments, and everybody please do get involved. And also we've got a second one, so do sign up for our second conversation on DPOs about moving out of the silo and becoming a strategic business partner and forward scoping.
Discarding the conflict piece.
Sorry?
Discarding the conflict piece. I think we've got
discarding
over that
the conflict. I think if I could summarize our conversation, I think I might do it in the way of, one, try not to have a DPO if you don't need one, so you avoid the whole issue in the first place. Be very wary of just using the title, which does make a bit of a mockery of the whole thing. But two, it's really all about advice and expertise to get compliant. And really, that's what we should all be focused on at the moment. I think in the market, I think DPOs become a bit of a term of art just for a privacy consultant almost, or someone who knows their stuff, rather than this particular role in the law. I think we've sort of said that external DPOs are something to really seriously consider as a way to address this conflict, because it's very hard to appoint someone internal without conflict. And then actually, in a practicality point of view, you're very unlikely to get called on this at the end of the day anyway. Would you say that's anything? Do you think that's a fair summary?
Yeah, and just for the internal piece and the conflict piece, like, a lot of people are going to run with very obvious conflicts that I think will be an issue. But the people that are unconflicted don't usually have the authority within the company, because again, the DPO needs to have that authority that people actually listen to them. So if you're completely unconflicted in your company, you're probably not in a role, or you don't have like that type of reach within the organization to get people to kind of follow you on quite serious matters. So, and I, having worked in corporate and the likes of that, when somebody external comes in, you're expected to put on your face of the business, and you have to have best practice, and you have to really show your work and comply and the likes of that. So I think that's just an extra point towards the outsourced piece.
That's a very good point. I think one of the things that I'm very jealous of with DPOs, I think DPOs are going to be in a very similar situation to in-house counsel. And I've did a blog post on there was a great survey on in-house counsel and how they felt about conflict basically and how they dealt with that. And one thing I'm very jealous about with DPOs is the business has to write down its decision to disagree with the DPO. So for me, that's just gold, because as a lawyer in-house, there are so many occasions where you go, we shouldn't do it this way, we can do it this way, and someone goes, nope, we're doing it this way. And I actually ended up, they called them Bob emails, and I would write an email to the CEO and go, I don't agree with this. This is the reason why. We've discussed it. By proceeding with this, you're recognizing I've given you this advice. And I PDF'd them and I had them in my CYA folder, so that it became known as a Bob email. But DPOs have got a great one, because that's actually built into GDPR. If they're not going to follow the DPO's advice, they've got to write down why they're not following it. I think it's a fantastic safeguard for DPOs.
Yeah, I suppose when I started my career in compliance, that was just common practice. It was like, if somebody doesn't agree with you, make sure it's in writing, and make sure you've CC'd the world so as everybody else knows about it as well. So if you've got a chief marketing officer that's going against whatever sort of advice, if you are just a privacy manager or a data protection manager, you want to be sending that email, you want to be CCing everybody in the C-suite to make it seen and known that the data protection manager or the person in charge of data protection, they're giving this advice. So while the DPO might be covered, if the company is clever enough to have understood whether they need the DPO or not, they've appointed a champion or a manager, whatever label, that manager should be following your Bob email examples and really covering their own tracks.
I think it's a very good point. And I think it's a fantastic safeguard for DPOs. Really, I really do. So just quickly on Brexit, we've gone slightly over time. We'll keep going because this is such a good conversation. So just very quickly on Brexit, to deal with that, because it was on the thumbnail. I'm in the UK, so I'll deal with that one. So basically, the rules on DPOs, as you know, are exactly the same in the UK GDPR as they are in the EU GDPR. So there's no change on whether you need one or not. And the tasks, the conflict bit is exactly the same as in the EU GDPR, and the decisions on the EU GDPR up to exit will still be relevant. So we don't see any change in the UK in terms of that DPO position. One little wrinkle is, where should the DPO be? And the EDPS did say, look, we wanted the DPO to be in the Article 29 Working Party, said it should be in Europe, but if the controller process is not in Europe, as an example, the DPO doesn't need to be in Europe if it's a way for them to do their job better. So I think, to all intents and purposes, Brexit hasn't changed yet the DPO bit for the UK.
Wait to be seen if there's this rollback of the requirements, but we'll see. That can be a different topic or a different episode.
Yes, definitely. That's another one as well. I think that's a highly political. I think they're just talking to a particular section of the Tory party. But so Tom, thank you so much. This has been a fantastic conversation. This is going to go up on the Privacy Kitchen YouTube channel very shortly, and also we've got our second one in the diary, and we can maybe deal with some comments that might arise from this one in that one if there's any left over. But we'll try and move on from conflict into how a DPO can move into being a strategic business advisor. So Tom, thank you so much for joining us in Privacy Kitchen.
Cheers, Rob. Thanks very much for having me.